and due to the behavior of the defendant, it appears accurate to say that he attempts to conceal and reveal his involvement simultaneously. That his dealing with the criminal justice systems are dominated by psychopathology. This court has carefully considered this report in an attempt to determine if the defendant possessed an impairment of his ability to appreciate the criminality of his conduct, or whether the perception of an extreme duress is within himself. This court is of the opinion that while the pathological needs for the defendant are consistent with defiance of authority and manipulation of all people that he contacts, as the report states, there is no overall symptomology of a personality disorder or substantial impairment of ability for the defendant not to appreciate the criminality or to establish the presence of extreme duress. This court has observed the demeanor and the actions of the defendant throughout this entire trial. And while a number of incidents appear antisocial, they do not, in this court minds, indicate or demonstrate a reduction of appreciation by the defendant of the criminality of his act. I find there are no mitigating circumstances in either circumstance E or F. The age of the defendant at the time of the crime finding. The defendant is now 32 years of age. There is no mitigating factor. The crime occurred January 15, 1978. Upon the preceding specific findings of fact, the court bases its sentence. It is of the opinion of this court that there are sufficient aggravating circumstances existing to justify the sentence of death. The aggravating circumstances are so clear and convincing that virtually no reasonable person could differ. The court is mindful that the sentence must be a matter of reasoned judgment rather than an exercise in discretion. See Rollerson v. State at 358 South 2nd, 826, Florida, 1978. It is this court's reasoned judgment that no mitigating circumstances, either statutory or by the testimony presented in the advisory sentence proceedings, which have been proven to this court, or exist to impair the thrust of the aggravated circumstances which have been proven to this court beyond and to the exclusion of every reasonable doubt. This court therefore agrees and concurs with the advisory sentence and the recommendation entered by the trial jury. It is therefore the sentence of this court, count 2 of the indictment, you, Theodore Robert Bundy, be adjudicated guilty of murder in the first degree, and that you be sentenced to death for the murder of Margaret Bowman. As to count 3 of the indictment, you, Theodore Robert Bundy, be adjudicated guilty of murder in the first degree, and that you be sentenced to death for the murder of Lisa Levy. It is further ordered that you, Theodore Robert Bundy, be taken by proper authority to the Florida State Prison, and there be kept and closely confined until the date of your execution is set. It is further ordered that on such scheduled date that you be put to death by a current of electricity sufficient to cause your immediate death, and such current of electricity shall continue to pass through your body until you are dead. The death sentence is imposed in both counts 2 and 3 for the deaths of Margaret Bowman and Lisa Levy, independently and separately. You're notified, sir, that a judgment of conviction and sentence of death under the law of Florida is automatically and will be fully reviewed by the Supreme Court of Florida. In other counts of the information, count 1, burglary of a dwelling and assaulting a person therein, it is the sentence of this court, sir, you've previously been adjudicated guilty, that you will serve 99 years in the state penitentiary. As to counts 2 and 3, the court has previously announced. As to count 4, attempted murder in the first degree, this court is of the opinion that the underlying felony in this count is indispensable to count 1, and the court will impose no sentence.